any latest UK VI updates that I have throughout the live. I'll provide brief answers to any UK immigration questions you have, including UK visa applications, EU settlement scheme, and British citizenship, etc., etc. I'll prioritize with the questions that come live with priority to members' questions, any of the memberships that you may have. So, channel members will be given the preference for the questions and then others' questions. And if I don't have any live questions in that time, I will take the questions which have been uh, put on the channel. So, if you stay throughout the live, I will give important updates frequently throughout the live, and towards the end of the live also I will give some updates that I have. So yeah, stay till the end if possible. I will be live for some time, about an hour or so. uh, Other viewers have benefited from previous lives, saved considerable costs on important answers to small questions, on decision makings, etc. So yes, that will benefit you as well. And about me, I am Sachin Sawant. I am registered with the Immigration Advice Authority in the UK at the highest level, level 3, advocacy and representations. I do represent applicants with applications as well as appeals, etc. So, enough about that. So, let's begin with no live question set. I will take the questions on the channel that are there. Let us start. So, anyone coming live can ask your questions. I'm trying to look up the questions on the channel. Hello, Munawar. So, is there any restriction on student visa for doing third masters by research? I don't think there is any restriction from the Home Office side, but I'm pretty sure when you try to get an offer from the university, I'm pretty sure if they want to sponsor you, they should have some kind of a progression or reason that they are required to justify to themselves before issuing you any cash. But yeah, that is for the university to decide and you to justify to the university. But there is nothing stopping you from continuously studying in the UK. So I'll take a member's question. So I have a question from the member. So we'll give priority to that one. Then I'll take the other questions. So Onia Stephen. So I'm currently on a skilled worker visa. I want to change employer. So he wants to change employer. My new employer has an allocation of one cost which he used for previous employee in 2023. This Feb 25, he tried make cost for me, but couldn't assign cost at the end of the form. Couldn't assign costs. I don't know whether they may not have the allocation, so I think that's what it looks like. But if you don't, yeah. But couldn't assign cost to him, what should we do? Some say we should demand increase. Yes, you should apply for allocations of costs. So you should apply for in-year allocations of costs. So that is my suggestion. You will have to apply for the cost if you don't have a cost. That one is done. So another live question from K. Alag. I'm on leave to remain under 10-year route. I'm planning to get married outside UK. Can I bring my wife to the UK? Leave to remain under 10-year route. What is the basis of that leave? If you can tell me, is it on the basis of being a parent or what do you have? Is it private life? Have you been an overstayer? Then you got this leave? Yeah, if you just clarify that, then I can answer your question. Thank you, Munawar Pasha. Thank you. Okay, next question on the channel I have is Keely49201. Can I ask a complex question? My partner and I will be attending immigration court shortly. So they will be going for an appeal, and I will be attending immigration court. So he has a deportation order against him, whilst we are appealing on the grounds of Article 8. So you are challenging the deportation order. Okay, it's a long question. Let me read it and understand. Okay, after some research, it seems it's possible to have it revoked, have it revoked, but after that, another application would have to be submitted. I'm hoping not, as I can't imagine having to wait again. However, I would rather know the situation. Yeah. So the question is, one, if the deportation order is revoked, then do you have to make a new application? So that is how I understand from the whole paragraph. yes, you have to make an immigration application. So just by virtue of the deportation order being revoked doesn't mean that the person will be granted leave. The person has to apply on the appropriate route after the deportation order has been revoked. So yeah, that is my answer. So Mr. K. Alag, okay, it's private life. I came to the UK as a minor under 20 years in UK, yes, but significant obstacles to relocate back to India. Visited India last year and just extended my 2.5 years. Okay, so you're on the private life route under minor. Let me think. So get married, dependent. Yes, if you do get married, you should be able to apply for your dependent. Yeah. Let me think through. If I'm a private life, can I get married? Yes. Yeah, you should be able to sponsor your family member if you get married. And so once you have the permission, I think Home Office cannot stop you from getting married and get into the relationship aspect of things. So definitely, there has to be a provision, and there is a provision obviously that you can also get married once you have permission in the UK. It doesn't matter what that permission is. In this case, your current situation I read through. So on the private life route, you have got it. Yes, you can sponsor your partner, but yeah, for the detailed advice, usually speak to an immigration lawyer, get proper advice, and discuss it. If you wish to discuss with us, book a paid consultation with us. The link is in the description. Okay, next question on the channel. So the question is on the. Thank you, Mr. K. Alag. Okay, good news for pre-settled status. So the question is on the pre-settled status video, where yeah, so Home Office has started the 5-year extensions of pre-settled status now. So that was the video that I had made where you are asking Abdul Qadir, but why they give extensions which after pre-settle you should get settled status. Yet you only get settled status when you apply for it. Home Office is not going to give it actively unless it comes in the automatic extensions. But if you are a family member or you have derived its status from someone else, like you are not the EU national, you're a family member, husband, wife, partner, or something else, then you have to apply for your settled status. And by default, Home Office is extending the pre-settled status just to give more time. The reason for that is if people, let's say they had some COVID absences, which are allowed to be disregarded, but to accumulate it the total 5 years, they have to do additional period. For example, they got it the leave permission, and for COVID they were out for 1 year, and that is allowed under the immigration rules. It doesn't break their continuity of residence. Their pre-settled status doesn't lapse. So if they've not, let's say the 1 year that they've lost on the COVID period, that is disregarded, but they have to top it up. So instead of completing 5 years, they would need to complete one more year of that absence. So that's called as disregarded. So in such cases, people are given that opportunity. Hence, that is the reason why those extensions are given, where any allowable absences are there, and you cannot complete the total 5 years for that reason, and those absences are disregarded, then the person can top it up and continue living in the UK and cover that period. That is the reason those 5-year extensions are given. And directly upgrading to settled status, it will happen. Home Office has declared that they will be starting. It will happen to a very small cohort of people, not to family members. Definitely, it will be only EU nationals whose national insurance records or DWP records that they are able to find out for a continuous period of 5 years from the end of the transition period. And it will be a small proportion of people that will be auto upgraded to settled status. So that is about your answer. Okay, Mr. K, it's 29K salary requirement. Can I show 29,000 saving instead of salary? No, the 29, the saving requirement is quite high. I think it is 88,500 or something. Let me calculate it for you. It is not 29,000. 29,000 is income requirement for any family route application. But if you want savings, then the formula is 29,000. I'm doing it on my calculator here. Let me see. I think it is 88,500 into 2.5 plus 16,000. 88,500. So yeah, so this is the number 88,500. Unit savings of 88,500 held at least for 6 months before the date of application continuously. So that is the requirement. Hi, SPL. Okay, so the next question on the channel I have. Okay, thanks, Mr. Alag. What can I do if I'm being made redundant? Okay, so on the video, I think for the skilled worker, where I have discussed the options, what happens, what you can do if you are being made redundant on a skilled worker visa. On that, Avani Arora has asked, I'm in the UK since last 4 years. My job is getting redundant. Do you know who can help with any job costs for switching skilled worker visa? Sorry, we don't provide skilled worker sponsorships or certificates. We are just immigration lawyers. We are unable to help you. Okay, next question I have is, sir, for skilled worker visa, LR. So I apply before 6 months. I don't understand the question. So for skilled worker visa, LR, I think you mean ILR. I will try to interpret it as much as I can. So I apply before 6 months. So if you want to apply for indefinite leave to remain on the basis of a skilled worker, you cannot apply before 6 months. You can only apply within 28 days of completing the 5 years. And the way it works is, let's say you are completing your 5 years on 28th of February, you can apply from 1st of February onwards, not earlier than that. If you apply earlier than that, the application is refused. I've seen many individuals where they send refusals and they applied just 29 days before. Yeah, instead of 1st of February, they applied in my example on 31st Jan, and Home Office does refuse the application. They consider it, they take the priority fees, about £4,000 in total approximately, and they will refuse it. So just be mindful on that within 28 days of completing 5 years. SPL, any information regarding skilled worker visa? The company here in the UK really stopped sponsoring the international candidate. Skilled worker visa company here in the UK really stopped sponsoring the international candidate. So I don't understand your question. The company stopped sponsoring the candidate. What do you mean? What is your question to me? Home Office cannot give update on if your company has stopped sponsoring migrants. So next question I have is, on the channel, can you please tell, I live inside UK, I give my biometric on 2nd December 24. Should Home Office conduct interview? I think UK. Yeah, the question is on the skilled worker visa. So yeah, Home Office has started conducting interviews even inside UK. So yes, if they don't believe in special is the same sectors that Home Office has been behind for the last 1.5 to 2 years now, where they last year Home Office cancelled about 1,500 sponsor licenses, most of them in the care sector, and now they are also very carefully and cautiously. This fairly new that inside UK candidates are interviewed. Just in the last 3 months or so, it has started approximately or so, where they can interview you even after the cost of once you make the skilled worker application. Ideally, they would interview you. Yes, it is possible if you file it on 2nd of December. Standard service for a skilled worker decision making is 8 weeks. You give your biometrics, so you enroll your biometrics 2nd December, 2nd January, 2nd February. So we are already past it. Not sure why, but usually it is not more than 8 weeks. Home Office does decide skilled worker applications within the 8 weeks. Yeah, maybe your lawyer or whoever it is should follow up with Home Office and see what is happening. But yes, they may conduct interviews. Yeah, that was your question. Just to answer specifically, anyone coming live can ask your questions. I'm taking the questions on the channel in the meanwhile. Okay. So the question is on skilled worker ILR absence letter. So the question is, please reply on my question. Okay, I got my visa in 2018 on private life. Okay, and on private life settlement. But this time my visa went for renewal. I get my visa on private life, so I can apply for indefinite on young adult. Please visit. Yeah, if you are on the young adult route, uh, you can qualify for settlement after 5 years. So There is a concession for all those young adults. You can apply for ILR after 5 years. It is there. Speak to an immigration lawyer, book a paid consultation with us, or speak to any other immigration lawyer. For the young adults, you have the concession where after 5 years you can apply for indefinite leave to remain. Okay. Another question on the channel I have: when does the 5 year count start for ILR on skilled worker visa? Okay, so you're trying to read the guidance where you say gov.uk means calculating specified continuous period. Applicants can submit a settlement application up to 28 days before they would reach the end of specified period. So as I said, up to 28 days before. So if they're completing 5 years on 28th of February in my example, they can submit the application on 1st of February onwards, not before that. Within 28 days, not before 28 days. You must calculate the relevant qualifying period by counting backwards from whichever of the following is most beneficial to the applicant: the date of application, the date of decision, any date of up to 28 days after the date of application. Yeah, I think you're asking me to interpret the immigration rules, but that is a summary. Anytime, this is how, yeah, I know what you are trying to write down the rules. This, to simplify it for your purposes, that is the answer. You can only apply for indefinite leave to remain within 28 days. Just to clarify again, if you are completing 5 years on the permission, on the skilled worker permission or any permission, you have the 5 year route, spouse visa permission, let's say. If you are completing it on 28th of February, you can submit indefinite leave to remain on the 1st of February onwards, not before that. So that is the within 28 days period. You can submit on 1st of February, 2nd of February, any time after that. So that is what it means, the rules that you have copied. Yeah, so just to interpret that. Okay, anyone coming live can ask your questions. Let me give an update. Let me open my update file from home office. I have noted some, making some notes. Where is it? Okay, so about the sponsor license, yes, I was on a sponsor license conference, I think a week before, about 8 to 9 days, about, yeah, about 10 days or so, I think. And there, home office senior person gave some updates on various items. So I'll just give some updates that I have. I made notes on. Let us see, where is it? Okay, so here is it. So first update was Home Office in the last whole year, whole 2024, Home Office has cancelled, revoked sponsorships of 1500, 1500. There may be an odd number, but I know they rounded it off. 1500 sponsor licenses in whole, revoked, not downgraded. Revoked means cancelled, where all the skilled workers on those licenses would straight away fall for curtailment usually, but then there is some exception going on where home office is helping the care workers and all, to giving them some more time. The only help they are giving is they're trying to connect the DHSC, Department of Health and Social Services, I think. Yeah, so with them somehow they're trying to give them the contact or something, and trying to help them to get another sponsor to switch visas. That's what the home office is trying. But I don't think there is much from the home office side. That's the best they are doing. Then they are doing only two things. One is they are not curtailing the visas, they are not cancelling them for care workers. Second, they're trying to give the connections or asking the individual to apply on the with the DHSC and try to find a relevant employer who can sponsor them. That is what home office best they can do, and that's what they are doing. Okay. Any updates? Yes, I have it. Where is it gone? This one. Mm. Okay, automatic grants of settled status will also start. That's what Home Office has confirmed. They will be starting the automatic grants of settled status. This is about EU settlement scheme. So that is also latest going on in the news. Uh, I have several other updates, but this is the one I will give and I'll answer some questions then. Uh, Home Office has started, so they are going to look at all the. There are only two records that they can look at summarily. One is national insurance records. If you have pre-settled status, you have worked in the UK for the last 5 years, This will only apply for the EU national, not family members. Remember, people always asking me about I'm the spouse, I'm the unmarried partner, or something, some family member of the main EU national. But I've made, I think, other videos also on this point. But these questions I get repeatedly, hence I want to address this. Only the EU nationals who have a EU passport, they have lived in the UK for 5 years, have national insurance records for 5 years, then Home Office may automatically, the system will may consider upgrading them. They may be offered settled status directly, or if they have DWP records, anything, pensions, benefits, or whatever they have been taking for last 5 years, that is another way how Home Office will know. So only they can only check automatic checks with their own government departments. They cannot go to a bank or somewhere and try to do automatic checks. I know people always ask this, and also I see several videos everywhere on TikTok and everywhere where people start making all these viral videos just to get views. This will be a very small cohort. Let's understand this. It is not going to be a very big cohort that everyone in the UK is suddenly getting settled status. It will not happen. There are many issues. Even many times I remember when we apply, it checks the national insurance records and the system throws back a statement saying, sorry, we couldn't find all your records. In spite of the worker having the records, I don't know what happens. But in spite of that, it doesn't give a proper answer. The HMRC systems don't communicate, or they don't give the proper information. In that cases, Home Office will not upgrade. Remember that the person. So it is always advisable to apply yourself rather than waiting for Home Office to auto upgrade it. That's my advice. If you have any gaps in employment, gaps in living in the UK, etc., etc., in those cases, yes, it may be a concern. In that case, you should speak to an immigration lawyer. You can book a consultation with us. Hit the link in the description, or speak to any other immigration lawyers. There is another live question, two of them. Let's see. Rashmi, hi Rashmi, Imanti. My Imanti, my cost working hours is 40. The salary just satisfied the minimum salary requirement, 26,200. Okay, will that be a problem when I'm applying ILR? Because my salary is not proportionate to the hours. So my cost working was 40. So I'm assuming you are already on a skilled worker visa and you are on the old rules, because 26,200 was under the old rules. Current minimum is 29,000 base. Uh, for that one. So I understand you are on the old rules, you are on the skilled worker visa. At the point of ILR, I'm assuming you have a 5-year visa because you don't have an extension. If you are having an extension to reach your ILR, then at the point of extension or at the point of ILR, let's say if you are applying directly ILR, your salary will have to meet at least a base of 29,000. Remember, so you will need at least one payslip. I know Home Office will get difficult at that point if your salary is 26,200 for 4 years and 11 months, and in the last month suddenly it becomes 29,000. So definitely Home Office will reverse investigate the sponsor left, right, center. They did this before also, when there was a minimum of, I think, 35,000 declared for a short period. It was about 5 6 years before, where indefinite leave to remain on skilled worker visa, there was a minimum of 35,000 or something. Employers would increase the salary on the last payroll. They would go audit the employer, take them left, right, center, revoke the sponsor license, and a big mess. So remember, it has to be genuine. Sometimes sponsors will try to help you and just try to give you a increased salary for one payslip because you need one for the ILR. That is not the right way to do it. So unless the sponsor is going to increase your salary, it has to be done genuinely only, and you will need that one payslip at least with the 29,000 minimum. So that's my answer to you. Abdul Rahman, on a pre-settlement status, have applied for settlement status. I am waiting for outcome. Recently convicted by the magistrates and sentenced to 140 hours of community service. I am registered as sex offender for 5 years. Will this affect my application? Also, do I need to inform them of the magistrate case outcome, or is this necessary? Already mentioned. You need to inform them any changes. So you may have to write to the EU settlement scheme resolution team or something, or upload a document on your. You can also log into your application. There is an uploads option. I know you may not be required, but you can continue to upload. That's what you can do. Usually, you can do it through lawyers if you don't understand how to do that. But yes, you should inform them. They will usually keep it pending if the judge has not given a judgment, either acquitted you or convicted you or whatever that is, any case that you have, they will keep it pending. If the decision has been made, so let's say whatever the problem you have. I'll briefly answer this, but for this, usually book a consultation with an immigration lawyer. You can book with us. We can look into the rules and advise you accordingly. But just to help you out, yes, you should report it. That's number one. Whether it will affect or not, it is something that has to be read in parallel with the rules. So for that, book a proper consultation with a lawyer. We need to see any information, documents, go through the rules and advise you accordingly. But in my first reading of the rules, the 140 hours of community service may not affect. But then if you are registered as sex offenders list, yes, that is something that needs to be considered. That is what I will say, not conducive to public good or something. So that one, book a proper advice session. So this, to this extent, I can answer this. Uh, you can book with us or any other immigration lawyer. That's fine. Savera Mustaq. If I divorce before 1 year complete living with EU husband, 1 year complete, I have pre-settled status, but I am divorced my 5 year complete in December 2025. So you're talking of retained rights. You are asking the question on retained rights, Savera. So for the retained rights, if you want to continue living in the UK after the divorce from your EU husband, the requirement is you should be married for at least 3 years. Number one, out of those 3 years, you should have lived in the UK at least for 1 year together. You should have cohabitation evidence of that. Thirdly, the divorce should be on the date of divorce. The EU national should have been a resident in the UK. They may be traveling outside the UK, but they shouldn't have left the UK permanently. These are all very critical points. These go in appeals, and also that's why I know all these. So these are 3 points. 3 years minimum marriage should have subsisted. That's important before divorce. And out of that, minimum 1 years, or even in your case, if it is 3 years, you will live together minimum. That should be fine. You have to prove all the cohabitation evidence, living together evidence, bills, letters addressed to both of you, either individually or severally, at the same address over the period of time you have lived together in the UK. So, and so that is my answer. Mr. Gillen, hi, how many maximum days can you spend on holidays on a 10-year route to settlement, leave to remain? I think they are restricting it to not more than 180 days outside the UK in any 12-month period. They have copied the same thing from other areas, skilled worker, etc. So it is not more than 180 days outside the UK in any 12 months period. It's a rolling cycle. July, I'm registered for use of this. Okay, and from your states. I need to inform. Yes, so that one I've answered. Harish, will you be able to help in Tech Nation Global Talent? Yes, with the Tech Nation, the only thing that any lawyer can do, I know other lawyers may promise anything nonsense. I have experienced, I have reviewed everything. The only thing a lawyer can input is we can review against the rules. Yes, I think you are in the technician game, so you know what the technician guidance and all is there. So we can review it against the immigration rules, the Home Office guidance, and see how better the application can be made. So it can be preferably a checking service or something. With filing an application through a representative, there are two stages in technician. One is the endorsement stage, and the stage two, which is the immigration application. The first one is not an immigration application, so you can file it yourself also. You can get it reviewed by us, all the documentation and all, something like that. That may be helpful. But then you will know more about your case mainly. But yes, we have experience of reviewing all the applications. We know what is considered, what is rejected, uh, what may be considered for a promise or a talent or something, 5 year or 3 year route, etc., etc. So we can provide a review of those applications. And yes, if you want representation for the Home Office application, yes, we do represent. If you're doing both together, yes, we can represent with that. If you're doing only the endorsement, you can file it yourself and then get it reviewed by us, something like that. Initially, to decide, you can book an initial consultation with us. There should be a link in the description, and take it from there. You can discuss, ask your questions, understand what we can do, and then take it from there if you want further services. Okay, so Vera, but sir, he divorced me after 6 months. There is any other option? Expect retained right for me. After 6 months, it will be very difficult for you unless there was some domestic violence and things were being raised. I know you cannot raise domestic violence now. If at that point something was registered, something was wrong in your relationship, there is a police record, medical record, anything, then on on DV, yes, domestic violence, there may be some possibility. But other than that, in your own right, if it was a normal divorce, mutual, everything, no children involved, then it will be difficult for you to get anything on that basis. Just okay. Thank you, Rashmi. I applied for FLR, 9 years ago. FLR, it was refused, and I made another application pre-action protocol before 7 days grace period. I waited after 3 weeks and received notice of removal from the Home Office. Yes, continue the question. I know you can. Then I will answer. Arshidhu, I'm care worker visa since 2022. This is tax. My salary is around 18,000 and 2k under 2400. Will that affect my application? Don't make full salary in year on the lower career. With the indefinite leave to remain, will it affect your ILR? It may or it may not. As of today, if you file an ILR today, if let's say I'm assuming you are qualified today, for example, I don't think it would affect. They look at the latest payslip and latest income. It may not affect. But by the time you complete your 5 years in 2027, the scrutiny may change. Home Office has anyways concerned with individuals not being paid in line with what was promised, etc., not being given work. Home Office may change the approach at that point. So, cannot promise at that time. But as of today, as per the current rules, yes, Home Office is not checking the past history of individuals. Munawar Pasha, one of my friends asking, is it possible to file an application 7 years childhood before she 7? She is 6 years old, born in UK and autism. If she's 6 and if Home Office is not after you, they have not arrested you and put you in detention and all, I would say rather just save your money, don't waste your funds now, and wait for 1 more year. Let the time pass. 6 years have passed anyways. Wait for it and then apply. Unless Home Office has arrested you, they are going to put you on a plane and it's really life and death situation. Only then you should file this application and try to see what possibility. Other than that, I would not advise filing unnecessarily just out of haste, and you would ruin your own chances later on. So that's my advice. Wait for the 1 year if no issues. Okay, so let me take the questions on the channel, or let me give an update. Okay, let me see if I have an update. I have something. Where is that? Mm, e-visa issues, yeah, e-visa ones, yeah. If you still, I think Home Office hasn't clearly. There are issues if you have uploaded your passport and your passport is the source document to access your e-visa. Then if you file any application, try to use the immigration ID check. There is some issue. It doesn't work properly. You have to fill the application and do for the appointment and all of that. So that is what is happening. That's what I have seen. That's what we've heard. Home Office has not sorted that out. I know they are working on it. If anyone has been able to successfully do any application through the app without attending biometrics, and you are using your passport as the source document, please let me know on the channel. Yeah, to the best of my knowledge, that problem still remains. Thank you, Arsh. Thank you. Okay, so yeah, don't update your passport unless you really need it. So you are traveling into the UK or something. If you are just staying in the UK and till March end at least, you are going to file your application in the next 3 months. You are inside the UK. You are not don't have any plans of traveling in the next 3 months till your application. Then yeah, just continue accessing the e-visa with your expired BRP. It's just a system issue, so I'm just telling everyone. Yeah. So what else? Let me take some questions on the channel. Okay, another e-visa question. Okay, Rashmi, I informed the Home Office after notice of removal. I informed the Home Office that I'm leaving voluntarily and to return my passport. I left voluntarily. I applied. If I apply for studies, will I get my study visa? Let me see your question again. I understood. 9 years ago, I was refused. So after the refusal of the FLRO was refused. After 3 weeks, receive notice of removal. Notice of removal. Yeah. So if you have not overstayed the UK after the, so I'm assuming your FLRO was filed on time, which is within time. You had a valid visa and then you filed FLRO. That was refused on whichever date that was refused. You left the UK from that point. I don't care about the other things, reaction and all. I know they will not be counted towards Section 3C. So when your FLRO was refused from that day, within 90 days, if you left the UK, then there should not be any overstay bans. And I'm assuming you left at your own cost. You bought your own ticket. So assuming you left at your own cost and it's 9 years ago, you should be able to apply for any visa that you are eligible for to the UK. So I think you're planning to apply for a student visa. Yeah, but remember they will check your intentions very cautiously. They will be interviewing you preferably to see that your intentions now are genuine because of that past bad history. Remember that. So yes, you can apply, but yeah, they want to see that you are a genuine student. So it's highly likely that you would be interviewed. And in your cases, definitely file your applications through immigration lawyers. Don't use those cheaper agents that you get in other countries. They just mess up, they answer wrong things on the form. I have seen so many refusals, agents just writing anything on the forms, and your lives be getting messed up. So get a proper immigration advice, do it through proper lawyers, through us or any other lawyer, but do it through proper legal representation. That's my advice. How much is your charges for ILR? Yeah, for the charges and all, yeah, please go to the website and just send an email to the office and they will send you the details. I don't keep a record. There is something they will send you. Yeah, so on the channel information, there is a link for, yeah, just click on the channel information on this one. You'll get the website. On the website, you should just fill up the inquiry form or something. Yeah, someone from office should get back to you. Okay, Mr. K. Alag, in 29K salary requirement, my contracted salary is 28K yearly. Can I show overtime to meet 29K requirement? Do I need another job on contract? Yes, overtime is counted. You are talking of the family route one. I remember that you asked, the reference that you asked. It is counted, so you can use your last 12 months of income, net income. That is fine. It should be okay. Have you done that in the past for spouse visas, family visas, and all? Thank you, Rashmi. Yeah. So 11:30. Okay, there are no more live questions. I will let me give one update, one or two updates. What I have. What do I have? Yeah, Home Office also said that for the pre-settled statuses, Home Office will start reviewing the status. They haven't given a date yet, but they will start cancelling the pre-settled statuses in simple language. That's called as lapsing of the pre-settled status. If anyone is outside the UK continuously for a period of 2 years, had pre-settled status, never came to the UK for 2 years, then by operation of law, the pre-settled status is cancelled. Home Office is going to do some research. They are going to see the data. They get all this data from all these airlines and carriers. So they are going to review that. At some point, they would start in this year only. They said in 2025, at some point, we will start cancelling those pre-settled status where people no longer are eligible for that. With the private life route, Mr. Kalag, can I show 6 months pay slip? Yeah, there is a calculation to be made. So you have to do the total of the whole. Yes, you can, but yeah, the calculation needs to be made properly, and only then I can advise. You need to speak to an immigration lawyer. They have to see all your last 6 months' salaries, total it, take the average, etc., multiply it by some factors, and then try to do the numbers. Yes, but with 6 months' salary also it is possible. Speak to an immigration lawyer, give them all the numbers, and do the total, and take it from there. That's my advice. Okay, yeah. And yes, I was talking of the settled status, pre-settled status once, and what was it? Other things. The cost fees, which is going to increase, that is still in the parliament. It is not yet passed, so the cost fees may increase up to. Currently, it is £239 for a cost certificate of sponsorship fees. It is going to increase to 525 maximum. It may not be exactly that, but yeah, very close to the highest. That's what Home Office usually does. But so be prepared that the cost fees, anyone who is planning to assign costs, assign them quickly before the fees increases to 525 instead of 239 currently. Next question, live R. I am on skilled worker visa, ILR due in 2026, okay, but my dependents have ILR in 2027. Okay, so you file your ILR in 26 and your dependents will have to extend their permission along with you. When you file ILR, parallelly both applications should go. We have done this many times, but usually, yeah, preferably do it through immigration lawyers. If you don't know how to do it, both applications need to go together, your ILR and your dependents extensions. Your dependence extensions will have to be applied for the, it's a standard application. You cannot get a 1 year extension. They will extend only for 3 years. Okay, you will pay 3 years of immigration health surcharge. We have tried it many times, but every time, yes, home office comes back and they ask for the 3 years IHS because that's how it is written in the immigration rules unless it changes at that point. So you have to apply for and pay for 3 years of extension. That's how it works. Okay, so I will I will end this live over here. Thank you very much, anyone who joined, and do subscribe to the channel. Consider becoming a paid member if you did get any value from this. There are other videos on skilled workers, FLRs. Those are the worst ones. People still getting. I'm getting. Yeah, that is an update. Yeah, I wanted to discuss on. Fee waivers are getting refused. After that, if you file an application, that will be refused. 101% that will be. I have seen several refusals on that because the requirement of the fee waiver is. I'll take the live questions. 1 minute. Let me complete my thought. Fee waiver applications, Home Office is refusing them. They are refusing them definitely on merits, and after that, people are trying to use those fee waivers to buy time. I've made several videos on fee waivers and FLRs, don't ruin your life, and all that stuff. In that, I've gone into detail, but this is also latest as of today. I'm seeing so many individuals sending their refusals of the applications which they file subsequently after the fee waiver, where Home Office is clearly writing down that on the fee waiver you said that you will make a family route application. Obviously, you cannot say you want to make a graduate route application or a skilled worker application. It's only for family route applications, the fee waiver. And now you are filing this. The guidance says the same application should be filed. Only then you get Section 3C protection. So you don't have Section 3C protection, and this application is refused. So it is a common thing that is happening. Don't waste, ruin your life. I will again say that by filing those fee waivers to buy time. I know it's free. It's very tempting to do it. You don't get anything out of it. If you are on a points-based route, if you are genuinely on a fee waiver, you are a family route case. You have all the you meet all the eligibility criteria, cannot afford the fees really on a family route application, spouse visa, parent visa, private life, and all those, that's a different matter. That's a genuine area. It's not a frivolous one. Only then do it. So let me take some live questions. One, Suresh. Does dependent child also need to complete 5 years in a skilled worker visa? He is 6 months short, but he born outside the country. 6 months short, yeah, he will not get citizenship. There you can apply for citizenship by discretion, but then that is if both the parents get ILR. Let me think. If both the parents get British citizenship, yeah, the child who is born outside the UK, and if he doesn't have any permission, he doesn't have ILR. You want to avoid the ILR fees for the child. That's what you're trying to get here. You can only, it would be only a reasonable chance of success if both the parents are British and the child is applying for British citizenship on discretion. Then there is a reasonable chance of success. But if your parents are just on ILR, or one parent is ILR, second is on a extended visa or something, no, the child will have to extend. The child will have to extend. They will not get anything because the child is born outside the UK. Always, in case of divorce with a British national, is the ability to inform the Home Office rests with the British national or on the spouse who was sponsored if the sponsored spouse left the UK? Um, the responsibility rests with the British sponsor, because when the applicant filed the visa, the sponsor confirmed, I am sponsoring this person because he is my husband or wife, and that is what they are undoing by saying I am no longer sponsoring this person. So the responsibility rests on the sponsor, on the British person, to report the end of relationship, breakdown of relationship, and fill up that form and report to Home Office. Viagra Envy embedded name on the BRP chip contains two of my three given names, but my BRP has all three names printed on it. Okay. When I try to confirm my ID through the UK via immigration app, it says details do not match. Yes, this is a common problem with that. If you have a long name, long spellings, and all of that, speak to, if you have time, speak to that web chat that have, you can Google search for e-visa web chat. You should get that chat, and maybe you get to a human being. It is monitored by humans. That's what Home Office has confirmed. Speak to them if they give any resolution. If not, then you will have to go through the application process and appointment process. You don't have any option. Home Office is still working all these fixes. This is a common one. I know I've seen many of these where the name issue comes up, where that exactly that error comes what you are stating here. Details do not match. So you don't have any option. If that helpline is not very helpful, you have to go through, we need to understand that the e-visa situation, the whole system is in the infancy. It's just been built. They are doing the trial error and trying to learn from it. So that's where home office is also, that's where we are also, that's where everyone is. So if that system is not helping you, you have to go through the application process. Okay. Satya Sudan. Fee waiver would you suggest for graduate visa holders to buy time in waiting on for my interview results? Interview results. What interview? Okay. No, I don't recommend few waiver applications to buy time or even those FLRs to buy time. If you have a genuine prospect of success, we have done many applications now. There are other case studies. For the last September batch, we had done, at least there are 3 or 4 videos on the case studies for graduate routes pending results, which we had filed and subsequently we had given the results. If your results would be out within about 60 days from the end of your permission, then yes, it is possible to apply and we've got it successfully. I would say 90% chances of success. Home Office may refuse it, 10% chances, because it's a validity requirement that on the date of the graduate route application, you should have completed the course of study successfully. But we have always had success. We've sent the results subsequently, but still, I will say 90% chances of success. Yeah, any lawyer who's trying to promise you success, they are lying to you. I can tell you that. They just want your money. But yeah, we will come upfront. If you wish to instruct us, you can. If not, your decision. But don't go with any of these buying time applications. They won't help you. FLRs, they will put you on immigration bail. Few hours when you make the application, your correct application, they will refuse it because you don't have Section 3C protection. You know, it's an out of time application. Okay, so that's where you are getting into. Yeah, for detailed discussion about this, of any situations that you have, even the graduate who's are pending results, etc. If you are going to get your results in about 60 days after the end of your permission, then yes, the pending results one may be possible. But yeah, for proper detailed advice, do book a consultation with us. Hit the link in the description, I would say, as other YouTubers say, and book a consultation with us for your immigration situation. And yes, FLR's also latest updates that I have is yes, Home Office has been refusing. Home Office has confirmed they are going to refuse any of these further leave to remain buying time applications. That is the latest update from Home Office and also from channel members when they are sending those refusals on emails or WhatsApp, and also they are commenting on various videos and they are saying that I have been given that immigration bail, etc., etc. So it is a common thing. Everyone is getting that. Students trying to buy time, skilled workers trying to buy time, graduate route holders trying to buy time, anyone trying to buy time for that matter. I would not recommend that. There are other solutions that I've discussed where pending costs skilled worker application can be filed. Pending sponsor license or skilled worker application can be filed if you already have a sponsor who is trying to apply for a sponsor license or who is trying to apply for a course, etc. Those we have done successfully many, many times. Pending results, graduate routes, we've done many, many times. So all those things are possible. Discuss with immigration lawyers, take proper advice. It's your life on the line. Radhe, live question: is UK going to increase the time for ILR? Yes, that thing, the new thing that has come from the politicians. I'm not going to make videos on that. I know people just try to make all these viral videos by putting saying ILR is going to increase to 10 years. It's quite highly unlikely. That's my opinion from whatever Home Office current position is. I know that these, I try to avoid talking politics every time, but yes, somehow I am always pulled into it. I think it's the conservatives person who has stated it, and it's kind of a vote bank situation. I would put it that way. There is that other party, I think UKIP or something. They are getting a lot of support from anti-migrant anti-migrant stand that they're taking. Hence, even conservatives are declaring they want something to say. They are stating this: we will make this thing, and this is what we recommend. They are not in power; they are in the opposition. We need to understand that. Obviously, yes, they can recommend all those things, but the final passing of the bills and all will remain with the Labour government. Labour government is quite on that. I don't think there is any intention. Labour government is not even increasing the financial requirement, which the Conservatives did say. As I will try to run a parallel with other rules over here, and then say what is the possibility of this ILR thing going up to 10 years. It's quite highly unlikely. I think 90% chances it won't happen, because it has been put forward by whatever, by the conservatives, which are sitting in the opposition. As much as I understand how the government works, so, and Labour doesn't have. They are even trying to not in reduce the financial requirement. That's why they had the spouse visa financial requirement. Last April, it increased to 29,000. Conservatives, when they were in power at that time, they said it would keep on increasing up to 38,700, 34,500. It didn't happen. We already touched it almost the end of December. It didn't go into the second phase. It's not going to go to the 38,700 also. So the spouse visa financial requirement is nowhere going to be increasing. I can tell you this almost 100% from my experience. It's going to stay at 29,000 or go down. So that's the reason the MAC advisory committee is checking into all this. They've taken all our inputs from individuals, from lawyers and all. And I think it may go down also. That's my opinion. So the Labour is not trying to, yeah, definitely they are not trying to take up the policies that conservatives has made. And obviously they are not going to take anything that new they are suggesting. I don't think so. So that ILR 10 years, yeah, currently I would take it with a pinch of salt. And I'm not going to make any viral video that all these other creators are doing it on TikTok and all just to get views. That's not right. Okay, I don't think it's going to happen. And unless comes on paper, it's in a bill format or something, yes, then I may discuss it. But just something in the news saying in front of reporters and all doesn't make much sense. Imanthi, yes, I'm on skilled worker visa. I'm getting salary from the parent company, but cause employer is one of my companies under main company. Is that okay? I think that should be fine. I think you may have with a big setup parent company and certain subsidiaries and all of that. Till the time they are meeting all their compliances, it should be fine. I know we work with corporates where we have structures of companies, and yeah, there are subsidiaries. There is only one license. Sometimes there are different licenses for the branches and all. So usually they do take advice from lawyers and all. So they may have structured it accordingly. Megara Senvi, do you know whether a finance professional who is going to take up an NHS job will qualify for exemption on skilled worker visa minimum salary? Sure, based on national scale applicable to. Yeah, I don't think so. You should look at the skilled worker salaries for healthcare workers. So there is a list of, yeah, healthcare workers. Only they will get the exemption from the minimum salary. If your job code is not on the list, you won't get it. Very simple. That's how you look at it. I don't care whether it is finance or anything. If your job, let me try to find it. Just 1 minute. Healthcare and HS jobs salary. Yeah, that is my answer. Yeah, so I with UK in UK currently. Yes, I am in UK currently. Yeah, this is UK. Okay, but there is a catch all code saying other professionals who are not covered. Other professionals who are not covered. But what is the reason for other professionals? Yeah, for that I have to do proper research on that before I advise. I don't want to give you wrong information, but unless your job code is on that list, it cannot be a blanket that anything, even let's say, I will just take hypothetical examples. Let's say a sweeper working there or a cleaner working there who is not there. He is also another professional working in the NHS, but I don't think they would qualify for that exemption. In the same way, that's where you also stand. I'll have to and speak to an immigration lawyer. They need to see your job description. That's the important one. The job description is what matters to home office. Only then it can be justified whether you qualify for any exemption or not. The job titles we don't care about, neither does home office. So job description is what matters. That's what I would say. Get it assessed. You can book a consultation with us. We can check your job description against the available job codes and tell you what is possible, what is not, or book a consultation with any other lawyer. So a proper research needs to be done. Emmanuel Belford, just can you do a tutorial video on how to report a relationship breakdown? I'll give you a simple answer over here. It doesn't need a tutorial. You just Google search for. I'll do it in front of you only. This tutorial. Let me try it. Okay. Report relation. Okay. See my form. So this is where it comes. If you search for report relationship breakdown to home office, so that was my search term, report relationship breakdown to home office. It comes up this one. So what you saw on the screen, you scroll down and then you say start now over here. Yeah. So this is my tutorial and you continue with the form. It's very straightforward. I know. I filled it for some clients who wanted us to do it. Sometimes clients just ask us, you can do it yourself. It's not that I'm not doing to upsell my services here. But yeah, if you have any questions, you can book a consultation and we can answer you about the form if you have anything specific. But yeah, just Google search for report relationship breakdown to home office. It is straightforward. Don't worry about it. Yeah, you cannot make any mistake on that. There is not much to do, not much mistakes that is possible. You are, it's basically a channel of communication rather than picking up your phone and calling someone and telling them my relationship has broken down. You're filling up on the form and telling them. That's it. So, Chibapas, good morning. I applied for fee waiver and it was accepted. Now I have a new course and I only have money for my IHS. Fee waiver was accepted. Very interesting. Uh, I only have money for IHS and visa application for now, but for my dependents, I do not have. In the fewer application, did you say that I'm going to file a skilled worker application? On the fewer, I'm sure you have to answer what is the application that I will be filing after you approve my fee waiver. Answer that question and then I will answer forward. Yeah, so I need to know that. What did you fill up on the form? If you have a PDF of that, open that form and see what did you write. Did you say I'm going to apply for a spouse visa, family route visa, or something, or what is that you said? I need to understand that. Then I can answer that. Because for skilled worker there is no fee waiver. I can tell you that. Yeah, so you have definitely written something else over there. And if you wrote something else, whatever that was, spouse visa, family route, parent, other private life, or something, then that fee waiver is completely null and void for a skilled worker application. Null and void means it cannot be used. So I'm using legal language over here. Okay, so Imanti Mendis. Does the salary of a person working on a skilled worker visa need to increase year by year according to the minimum wage when applying for ILR? For ILR, I don't think Home Office cares about that, whether the salary has increased year by year. But the employer's regulations, where they should at least pay minimum wages, that is required. That is a requirement of the sponsor license. If the Home Office does an audit, or however they come to know the employer is not paying minimum wages, they will revoke the license. They will straight away revoke the license. There is no ifs and buts over there. They are not meeting the laws of the land. You need to meet all the rules of the land. For example, if you're a restaurant, you should have the food registration to prepare food and sell. If you are, if you're a lawyer, if I'm doing a business, I need the registration and license and insurance to do the lawyer's job. In the same way, minimum wage payment also is a law of the land or that of the UK. If you are doing a business in the UK, you need to pay minimum wages. Employer may have issues with their sponsor license or other things as well. But with ILR purposes, it's not your problem because it's an abuse for you. So Home Office cannot hold that against you. I applied for family route even though I do not qualify. Yeah, you cannot use that fee waiver. They will refuse your application. I'm telling you, they will refuse your application because on the guidance for the fee waiver it is clearly written you can file the same application that you filed for. If you go on a family route, you don't qualify for family route, yes, that application will be considered and refused on its merits. But then if you file a skilled worker visa and you said I'm going to, when you file the fee waiver, you said I want this fee waiver to file a family route application. Now when they approved, you're saying no, I don't want to file that, I want to file a skilled worker visa. If you use that, it will be refused. I can guarantee you that. Okay, so and even if you file another application, you may not have Section 3C protection. Yeah, let us know how it goes. But I don't even think, because you are not in time, you don't have Section 3C protection. I'm not sure whether you can even file an inside UK application. If you do successfully file an inside UK application, definitely let me know. It will help others on the channel. I will update others that if you get successful waiver on a family route, you can still do an in-time application from inside UK on other areas, skilled worker or anything else. But I don't think you can file an inside UK application. If I'm representing, I would not file inside UK. You should do an outside UK application because the rules don't permit that. You are already out of time for any application other than a family route. So, Emmanuel Bedford, if you separated from your partner and your partner goes to report to the police that you've not been working with your sponsor, will you have an issue with your visa? Not, if you separate from your partner and your partner goes to report to the police that you've not been working with your sponsor, what do you mean by that? I don't think police cares about whether you're working with the sponsor or not, and I don't think that's how the home office would come to know, or I don't think it would have any effect with your sponsor side of things. That's my answer. Police cares about the police side of things, domestic violence and all that. They don't get into other areas, and I don't think there is any not working with your sponsor does not affect much things. Yeah. Chibaba, I was just buying time waiting for my new course. If I apply my own visa, whilst I do not, or my dependent, will they be overstaying? I think you cannot even apply for your own visa. I can tell you that. Try doing that, but yeah, I think it will be refused. The reason being, as I told you, the immigration rules. You file a skill waiver application. You say I want family route, and on the basis of that, now you can only make a family route application. You cannot make a skilled worker application. Remember that. Your Section 3C is not protected for a skilled worker application. Your Section 3C is only protected for a family route application, which if you file, will be considered on its own merits and it will be refused. So my advice is you should go outside the UK and file an entry clearance application for all of you all. That's my best advice. You can try doing this, but if you get success, I'm strictly talking from the rules, what it is written in the guidance of fee waiver, etc. But yeah, good luck with that. If you still wish to file in the UK and if you do get success, yes, let us know, or whatever your experience is from inside UK. Other lawyers may disagree, but then it's your life on the line. Remember that. Aman Jamunda, I came through psychiatric hospital in a valid visa. They done my ticket. I was patient in schizophrenia. Can I go to UK and not this was mental disease. So you came to the UK with some valid visa. Okay, the hospital did the ticket and all. And what? I was patient of can I go to UK? Yes, if the hospital, yeah, you're talking of private treatment in the NHS. So if you have the letter from the hospital and all of that, yes, you can apply for a visa. I think if you already have that visitor visa, medical visitor visa, you can come to the UK. If you have and you have the visa and you are going to do the visit for medical purposes. Oman, yes, definitely Chibaba. Thank you. Sorry, but I have to tell you what the rules are. I'm sorry. Yeah, Imantu Mendes, my last question. My first question was I was working more than 37.5 hours, cost 40 hours. Salary is 26,200. Is that okay? Yeah, on that, the numbers and all, yeah. I don't know if your employer, my first question is I'm working more than 37.5, cost says 40 hours, but salary is 26,200. Yeah, as of today, it may not affect you, but at the point of ILR, your salary has to go up to 29,000. That was my answer, and that's what my answer remains. As of today, unless the sponsor is audited and all, they may lose a license for paying you less and all of that. That's a different issue. But then for you, it will only affect when you extend your visa or you file for ILR. You should have the latest salary. Minimum would be 29,000 for you with the new cost. Emmanuel, what I mean is that if you are on a skilled worker visa in care and you just separated with your partner, she goes to report to the police or home office, you've not been working with your sponsor. Yes, I understood, Emmanuel, that I don't think that will have any effect. I understood that question very well. Aman Jamanda, I was little bit mental patient on dependent visa. Came in my visa. Can I go to come back? So I am assuming, Aman, you want to come back as a medical visitor, and you have the money to pay for your for whatever your medical treatment will be. So yes, you can. You were a little bit mentioned patient on so you were on a dependent visa before. You had some mental issues, and I came in my visa. Can I go? Yes, you can come if you can pay for your visits. You qualify the requirements for the medical visitor visa. Speak to an immigration lawyer. You can book a consultation with us. Hit the link in the description. Anyone who wants immigration advice on this or anything else, yes, you can do that. And no more live questions coming through. I've been live for an hour. Anyone who has got any value in this live or any other videos, do consider becoming a supporter of the channel. There are two types of memberships, just £2 or £3. Yeah, it supports YouTube as well. I think then they show more of these videos or something. But yeah, most of that goes in donations and all. Thank you very much. Thank you, Imanti. Thank you, visitor visa. Yes, you can apply if you do meet all the eligibility requirements. Medical visitor visa, I understand. Shera, can I get my fiance on dependent visa? I am not married yet. Fiance on dependent visa? No, you cannot. There is no provision in the immigration rules. Okay. Thank you very much, anyone who joined this live. I'll be ending this live. Thank you.